An important outcome of the Hunter McKelvey report was the recommendation of an equality of opportunity model briefing policy, which was endorsed by Victorian Attorney-General Rob Hulls in late 2000 and formally adopted by the Victorian Bar Council in April 2004.
I've definitely inherited the benefit of the WBA, and I'd also like to say I've inherited the benefit of the Equal Opportunity Committee and the Equality Before the Law Committee prior to that, which is a committee of the Bar Council. And particularly, I think one of the big changes that has been made is the model briefing policy. The WBA has made great progress, but we still suffer actually from a lot of misinformation out there, that there is a belief that there is a quota system from the government for briefing women, and that breeds a lot of discontent. It breeds a view that we are taking food out of other people's mouths, that we are getting briefs in circumstances where we are less qualified for them. So yes, we've made great progress, but there really are still some very large cultural issues that need to be dealt with.
Women were getting less well-paid briefs and not getting briefs that were senior, and not getting briefs in areas where traditionally the males dominated, such as commercial work, and not progressing, and that was still the case in 2003. One of the achievements for women barristers is that we managed to not only just win over many of the men within the bar, the men with power, but we went outside the bar and we approached government directly and asked them to support us and to stand behind their equal opportunity laws and implement it appropriately. So we went from moral persuasion, which was the model briefing policy that came out of the report, and we moved to commercial persuasion. And the commercial persuasion has had some effect, but from where I sit as a judge, it hasn't had enough of effect because there still aren't women briefed in trials before me in civil matters, and I don't know why. I just, I despair. I don't know what my colleagues' experience is, but in the common law jurisdiction, I rarely have a woman running a matter before me.
Because I'm sitting up on the bench now, and I'm actually seeing in 5 years as a judge, I have had 4 women defend a trial. Right? Plenty of women prosecute. 4 women have defended trials. It's absolutely disgraceful and disgusting. I had actually no idea. When you do civil stuff, if it's a government department controlling the briefing, such as Office of Public Prosecutions or TAC or Workers' Comp, there will be women there, usually, if it's in civil, as juniors. But where it's private enterprise, which is defence work in crime and plaintiff work in civil, it's blokes, wall to wall, shag pile carpet blokes, I'm telling you, and it's really disgraceful.
When I was convener in 2004, I opened up the Financial Review, reminded of this I was looking at today, to see a table of where the Commonwealth work had gone over the previous 2 years. And the article by Chris Merritt made a number of points about who was getting the work, but I was prompted to write on behalf of WBA, and I commented that one aspect of this table was very clear. Of the 46 names listed as having been the barristers who'd received $5.5 million in Commonwealth work over the last 2 years, only 2 appeared to be female. It got even better. The 2 were at the very bottom, and the 8th of the bottom of the list, which set out earnings in descending order. The 2 earned a total of $9,484 out of the $5.5 million, a proportion of 0.17%. And to put it in context, I pointed out that the women currently made up approximately 14% of the New South Wales Bar and 18% of the Victorian Bar, being the 2 largest bars in Australia. Now, in the letter, I went on to say this is why we have the model briefing policy, not to ask people to brief any sort of quota, but to consider whether there might be an equally meritorious female barrister on occasion as well as the males.
Institutions have to be prepared to give to everybody at the bar the same opportunities as they give to the men. They were briefing Felicity and Lillian and Betty because they were bloody first rate, having learnt their job, not on the support of the Legal Aid Commission of Victoria, but by sheer dint of having someone brief them, God knows who. But they'd got to the top and then suddenly institutions would brief them. But for the men, it was a different kettle of fish. They got institutional support from the beginning. And that is the fundamental point. There has to be institutional support for everybody, not just for the men. It's a matter of simple equal opportunity.
The Bar, I know, introduced a directory of women barristers, and obviously with the view that, solicitors can no longer plead ignorance of which women are available and what their areas of expertise happen to be. But from what you're saying, Fran, it's not making a great deal of difference.
Speakers speak to themselves. I mean, it's distressingly so.
Yes.
But they seem to. And I must say, during the report process, I was the representative sent to the Legal Aid Commission. And during the discussions, I was aware that they knew what their situation was. This is in 1998. They knew that their figures were very, very bad. And I knew that because I had someone on the inside who'd done some research. And I knew a report had been prepared. And when we went to them, we said, look, we understand there's been a report. And the new then director, oh, no, we've looked and we've searched. There is no report. No, there is no report. No, we are wonderful and we are heroes. And no, of course we brief women. And they do in the Children's Court and the Magistrates' Court. Fantastic, good on them. So they ought. That's not the point. The point is if you're not getting the Court of Appeal work, you're not getting the trial work. That's really the import of all of that.
Judge Lewitton, you just had a point to make.
I just want to say in the county court, I think that the model briefing policy has kicked in.
Has it?
I think so, because I see women being briefed by legal aid in the criminal jurisdiction. I see them being briefed in the serious injury jurisdiction. I've just finished a jury trial where the barrister was a female. So I think that it has kicked in, but probably not at the Court of Appeal level, and probably part of the reason why they're being briefed by legal aid in the criminal jurisdiction is that it is not very well paid, and perhaps the women are more prepared to undertake that work than the men.
Because I think the model briefing policy has worked to a point, and it's groaning, I think, under the stress of us all trying to reinterpret it and say, how can we make this better? I don't think we can make it better because they all say they've adopted it. But the results, the surveys that Carolyn has done and others have done are not there.
Well, actually, let's touch on this survey that you did, Caroline. You're immediate past president of the Women Lawyers Association. You're also assistant convener of the WBA at the moment. What are the main findings of this survey?
The main results nationally was extremely disappointing that women were not appearing in any significant numbers in the superior courts around Australia. And I think the statistics in the federal court were particularly disturbing, where they looked at number of appearances and also length of time of appearances, because length of time is a direct correlation to monetary outcome, amount you paid. And in the federal court, silks, male silks were appearing on an average of, say, 200 plus hours within the survey period, and female silks is 1 or 2 hours within that survey period. Same situation was in relation to juniors in the federal court during that period. It's very disconcerting if appearing as a junior in a long commercial trial, or in any sort of trials, is your teaching ground. And if women are not being given the opportunity to learn in these big commercial matters, that's, it's quite detrimental. But as I said, all the other courts, senior courts, women just weren't appearing. And we're talking 10 years post, well, 7 to 8, 9 years post the VWL, the Victorian, Vic Bar survey, and I just don't think a lot's changed since the Hunter report in 1998.
So you were saying, in other words, the trickle-up theory is not working?
It's not working, and I don't know exactly why it's not working. I've got a variety of theories, which we will talk about, and ideas, but I really think that more empirical research, more academic research needs to be done into why this is happening. I mean, it's all very well for us to sit around the table here and speculate why this may be, but we need sort of more research into why this is.